Chair, we're live.
Okay, great. Thank you. Good morning, everyone. Welcome to the March 2021 meeting of the Joint Commission on Public Ethics. The meeting is now called to order. We apologize for our delay in starting. We had some technological challenges. This meeting is being held using video conferencing technology. The public session of this meeting is accessible on JCO's website to watch via live stream. A couple of important reminders. It is important that only one person speak at a time. In addition, I ask that when you speak, you identify yourself so that we have a clear record. We will take votes via modified roll call to ensure that everyone is properly counted. And please also remember to mute your phone when you are not speaking.
Madam Chair, if you could hang on 1 second, I do hear somebody has competing audio, so please make sure you mute that because it's coming through the speakers.
Judge McCarthy, that might be your phone. I'm not sure.
I think we're okay now.
Okay, great. Deputy General Counsel Levine, do we have a quorum?
Yes, we do, ma'am. We have all 13 members.
Thank you. So let's get started. The second item on the agenda behind attachment A is the approval of the minutes from the public session of the last meeting of the Commission held on February 23rd, 2021. Are there any corrections to the minutes?
Yes, ma'am, there are. There's one correction on page 4 in the first full paragraph in the very first sentence. Word is missing. It should read several commissioners weighed in on the issues. And then there's one issue to note. It won't result in any change, but on page 7, the motion at the end of Romans 6, Commissioner Fisher was not recorded. We lost his audio and video feed, and the same thing occurred in the motion in Romans 7 to go into executive session. Commissioner Fisher was not recorded. While we can't change the minutes to record his vote, he did ask that today's minutes reflect that he would have voted against the motion in Romans 6 and for the motion in Romans 7. So we will record that today for him.
Okay, thank you very much. Are there any other corrections to the minutes from any other commissioner? Okay, great. Can I please have a motion to approve the February 2021 minutes of the Commission as corrected?
So moved. Deering.
I see Weissman.
We have a second?
Second.
All in favor?
Aye.
Aye.
Please keep your hands up until I've called your name. Braun, Fisher, Deering, McNamara, Weissman, Yates, Varlack. Sorry, come up, Commissioner Cohen on the minutes.
Yes.
Commissioner DePiero.
Yes.
Commissioner Horwitz.
Yes.
Commissioner Jacob.
Yes.
Commissioner Levine.
Yes.
And Judge McCarthy.
Yes.
Motion carries.
Thank you. Let's move on to item 3 on the agenda, report from staff. General Counsel Stan.
Sure. The monthly operations report for the month of February is attached at tab B. The only thing of note is, again, the numbers of calls and emails coming in for lobbying assistance is still very high. We're expecting it to drop off soon as the bi-monthly reports were due, but we'll see how that goes. We're happy to answer any questions about the monthly report.
Thank you. Anyone have any questions or comments? Okay, great. Moving on to item 4, the delegation of authority to staff. General Counsel Stan.
I think this is a matter of commission discussion. Commissioners have asked that this matter be placed on the agenda, and there is a proposal that has been circulated. So I leave it for the commissioners to have discussion.
Okay.
If I may,
Yes, thanks, Commissioner Yates.
okay. This is a topic that that's been discussed before, although this motion is different from anything that has been proposed before or voted upon. The question comes down to this. The law requires, regulations require, in at least 4 different places, that the commission approve certain activity before it be engaged upon by various officials. In particular, the statewide elected official, the governor, the attorney general, the lieutenant governor, the comptroller, or a commission head or the head of the department wants to engage in certain activities, the law requires that they get the approval of the commission. That includes things like outside income ventures, outside activity, fees or payments for services, travel reimbursements when it's paid by either an interested party, a lobbyist or not, and honoraria, and certain activities, and whether or not certain lobbyists may engage in, may retain someone to act on their behalf in a contingent manner that is based upon either equity or stock shares that might be provided, which might depend upon the success of the venture. All of those activities, according to regulations, require approval of the commission. We have had in place for a number of years a resolution which allows the commission to delegate certain decisions and activities to the executive director and indirectly to the rest of the staff through that. When the decision is between meetings and when a decision needs to be made between meetings and it's based on precedent. I will acknowledge, although I take a strong position on it, I don't feel like reigniting the debate. There has been a question which has arisen as to whether or not the delegation to the executive director to issue informal letter opinions is the equivalent of the commission approving outside activity or outside income or honoraria, et cetera, by a statewide official. It turns out Commissioner Fisher and I had competing resolutions, and I thank Bill for this, Commissioner Fisher. He's engaged with me in a what I think has been, and I hope will be, a productive process of exchanging different forms of the 2 resolutions. We're now up to what I call version 8, which is the one that was sent to all of you. And what it tries to do is the following, and that is, it turns out upon research that the staff, and through the executive director, through the informal letter opinion process, has, quote, approved, unquote, about 30 to 40 decisions a year, or applications made by the governor or commissioners or statewide elected officials in those 4 areas. We have had a lot of debate over whether or not those letter opinions properly constituted approval, and whether or not the approval that was required by the regulations was ever met. One issue of great concern to a number of our members has been that we're completely unaware, or have been completely unaware, of almost all, if not all, of those opinions or decisions that have been made. It is in the normal course. I'm not faulting staff for not making something necessarily available upon request, but in the normal course, the applicant, the governor or the comptroller or whomever, the attorney general, talks to staff through counsel or directly, gets an opinion, considers it to be an approval, and the commissioners, myself and other commissioners, not only weren't aware of the decision, didn't even have the underlying materials. We didn't even know what the application was based upon or what the question was. And those letter opinions have always been treated as confidential matters, which is why staff has not generally distributed them. So without faulting anybody, I'm not trying to resurrect history and say whether anything was right or wrong in the past, but going forward, I get the strong sense, and I hope a majority of the commissioners agree, that in certain areas, when the regulations require approval by the commission, for those limited number of cases, the 30 or so each year, or 35 or so each year, where the governor or the comptroller or the attorney general or a commission head asks for approval to engage in some outside income or activity or venture or travel, that the commission be aware of it and it not be made by dint of an informal letter opinion and a private conversation with staff, which has been the past. Now, Bill Fisher, and I commend him for this, was open to the prospect, even though he voted against my earlier motion, which was broader, and he raised a couple of legitimate concerns, which I hope are addressed in version 8. He said that minor travel expenses as a routine matter don't necessarily require a vote of the commission. And he asked that if there's going to be a fee for travel reimbursement or a fee for speaking or performing a service where the money goes to the state anyway, if the amount that's paid is less than $2,000, that we delegate that to the staff. We don't need to approve it as a commission matter. I'm willing to accept that, even though it's a variant of the general proposition that no approvals can be done by staff, that we can't delegate that matter. But I think for things that are de minimis, like a travel reimbursement less than $2,000, I think Commissioner Fisher raised a good point. I also commend him for carving out an exception to that, and that is if the travel reimbursement or fee is offered on behalf of or by an interested source, somebody who's a lobbyist or a client of a lobbyist who has a matter of concern pending in front of that statewide official, that in that case, you would still require approval of the commission, regardless of the amount, even if it's $1. And I thank him for that amendment. He also raised another good point, and that is, since there was a question in the past about the scope of delegated authority, are we really going to go back and try and unwind past decisions? He recommended that we go forward, that people had the right to rely upon a good faith application and approval in the past, and that it's not worth us going back. And I agree with him on that. There was ambiguity in the past. We're trying to lend clarity with this resolution. And so I agree with him that the resolution which lends clarity is one which should be prospectively applied. There's a third matter and a fourth, and then I'll pass it on to the rest of the committee. The third matter is, what do we do with the informal letter opinions? What force do they have? The statute says that when there's a formal application to the full commission, that we may publish a redacted form of it for the edification of the public and the covered parties. There's no mention in the statute of informal letter opinions at all, no reference to it. So the question is, will they have force and what do we do with them? Commissioner Jacob has rightly pointed out that there's a parallel system in the SEC, which has worked for years when you have staff opinions. So the decision was made in version 8 to do the following, and that is, if an applicant asks for approval or an opinion from staff, and they present all the facts, they don't omit anything, they don't misstate anything, going forward, then as to that particular matter, that party will have safe harbor and will be able to rely upon that informal letter opinion. But if in the view of the commission, that the staff decision which was made was one which is not the commission's position, and the commission would rather reverse that as a matter of policy, we're free to do so. We still have the authority to do that, but it would not affect the reliant party who had depended upon the informal letter opinion, but it would be a modification going forward. And as with formal opinions, we would have the right, the commission would have the right, the discretion to either publish in a redacted form an informal letter opinion, just as we do with formal opinions for the edification of the public, or not. We could maintain confidentiality if we thought it was a matter that didn't deserve or require publication. And then the last item is something that Commissioner Jacobs raised, which I think a number of the commissioners agree with as well. And that is that in the past, we didn't really know. The commission wasn't really aware of the letter opinions, the facts underlying them, or even how many were issued, or to whom, or for what matter. So that the resolution now carries a provision that there would be a schedule attached at our monthly meeting, so we'd be advised as to, the commission would be advised as to who sought, which statewide official or commissioner head or attorney general sought an opinion, an informal and a letter opinion, and received one, and what was the subject matter. Now, this, of course, will be confidential, just as the informal letter opinions themselves are confidential. But at least the commission within the commission would be able to look at them, and commissioners, every commissioner individually and collectively, all the commissioners would have the right, if something caught their eye that they thought was worth further examining, they'd have the right to see the submitted materials, which is something new because other than I think maybe one or two commissioners I'm aware of have actually tried unearthing prior opinions and reviewing them. I think for the majority of the commission, including myself, we've been in the dark as to prior letter opinions, and that would no longer be true. And so that is version 8. And I don't know if at this point I should try and move it, or if you want to just have discussion on it.
Thank you, Commissioner Yates. That was actually an incredibly detailed walkthrough of sort of where we are. And I very much appreciate your efforts as well as that of Commissioner Fisher and others who have worked on this document. I absolutely want to hear if any other commissioners have questions or comments. I'll note that I think the most recent version, version 8, was circulated yesterday. And so I'm not opposed to continuing with the discussion and answering some questions here and saving a vote until the April meeting, but I open it up to the rest of the commissioners to ask any questions. I think I see a hand raised in Albany. Is that Commissioner Fisher?
Commissioner Fisher, thank you, Chair Farlak. First, and I'll keep my remarks brief. First, I want to thank my colleague, Commissioner Jim Yates, for all the work that he's put into this. And there are a number of people, including Marvin Jacob and others, that also provided great feedback. I'm very satisfied with the form, and I saw all versions up to and including version 8. And Jim did a great job explaining some of my concerns. One that I would like to bring forward is that I didn't want this change to interfere with the regular process of our professional staff. And another one of our colleagues, George Weissman, I believe, looked at 2 years worth of these opinions. And I believe, George, that you found one that you would have disagreed with. So the rate at which they do exactly what we would have done is extremely high, and we wouldn't want to create real inefficiency issues by bringing so many things back to us that it interferes with their work. The only other comment I'll make, and this is just based on a brief conversation I had with Commissioner Deering, who's here with me, he received it yesterday. He hasn't received any information about this from General Counsel or Deputy general counsel, as I and others have benefited from. So I think it might be wise to let the other commissioners who just received it yesterday to have a little more time and to receive counsel from our attorneys if they feel that's necessary, and to hold off until the April meeting. But I would very much like to join in a motion in April to see the adoption of this, hopefully in its current form. And those are my remarks, and I'll go on mute.
Thank you, Commissioner Fisher. General Counsel Stam?
Yes, I just wanted to clarify one point, which I don't think affects the substance of the delegation in any way, which is just that commission approval is required under these reg parts that are referenced in the draft delegation, but really outside activities, official activity expense payments, and honoraria. Commission approval is required for all policymakers who engage in these activities under the conditions set forth in these regs. So it's not just the statewide and agency heads for whom commission approval is required. Staff gives guidance on the rest of the state officers and employees who are covered. And I don't have numbers of letter opinions, but I just wanted the full commission to understand that. But the way the delegation is written, I don't think my point affects it in any way. But I wanted to just ask a point of clarification with respect to paragraph 3. And this references a schedule of informal letter opinions, but from the way Judge Yates presented it, I wasn't clear if you just want a log of informal letter opinions to the agency or heads and statewide, or you want them for all informal letter opinions that are issued. Either way, staff can accommodate it. I just wanted to make sure there was an agreement on what paragraph 3 was asking for.
Thank you, Monica. I'm going to pass that one to Commissioner Jacob and Weissman. They were the two who were most concerned about this. Oh, and Braun too. I think Commissioner Braun on several occasions said that it's important that commissioners be more aware of what's going on. So I put that last one in. That's language that Commissioner Jacob proposed, and I know Commissioner Weissman and Braun endorsed. So I'm going to pass it to them.
Chair Valor.
Yes.
This is Marvin Jacob, and I had intended that we're all as commissioners, I would like to understand the development of the law that we deal with, and unless we see all of them, we really don't have a good knowledge whether they go to statewide or others. So the answer is, from my standpoint, all, and that word should be inserted. And that's a good catch, Monica. Very good catch.
General Counsel Stam, any additional comment on that point?
No, I think that was just, I think that was really it. And so, like I said, I think that the delegation as written is clear that for anyone who's not an agency head or statewide, staff will continue to operate in the normal course. And then with respect to what is now being called approvals, that will be handled differently. But I think the rest of it is clear, and now we understand what paragraph 3 means.
Okay, thank you.
Just for all commissioners to understand, staff issues informal letter opinions. We also take phone calls and emails. So, we have, we looked at 2018 and 2019, there's more than 1,000, inquiries that come in. They don't all result in informal letter opinions. And so a handful do, and we haven't been tracking it in that way to date, but we will come up with a method to track when they result in informal letter opinions so that we can pull this in some kind of from our log in an organized way to present it to the commission in executive session.
Thank you, General Counsel Stam.
If I could add,
Else.
being relatively new to the commission, I did want to see informal opinions from the past, and I did state that I thought we should have the opportunity, we the commissioners, whoever wants to among us, to see informal letter opinions that have been issued by staff. I commend Commissioners Yates and Fisher for all the work they've done, Commissioner Jacobs for what he added on this point. And I believe strongly that it should be all informal letter opinions that are issued. We should get a listing of them, and each commissioner have the opportunity, if he or she wants, to see any or all of those informal opinions, so that we can be aware of what's happening and what should be done if we think something should flow from there.
Thank you, Commissioner Braun. Any other commissioners would like to be heard on the delegation? Okay. So as mentioned, I do think it would be helpful to give some of the commissioners that have not been as involved in this the opportunity to just review it, and again, to Commissioner, I think it's Deering's point, be able to speak with our general counsel and deputy general counsel should they have any questions on the impact of this resolution. Does anyone object to postponing a formal motion on this to the April meeting?
If I may, I was going to make a motion to move it now, but I won't. I'll hold back. But with one caveat, I would ask that if there is in the interim between now and April, any request by any of the affected statewide officials for a letter opinion, that we as commissioners be advised between now and then so that we have an opportunity to be heard before this takes effect.
General Counsel Stan, do you see any issue
Sure,
with that?
we could certainly do that.
Great. Thank you, and thank you, Commissioner Yates. Moving on to new and other business. The first thing is behind tab C is the meeting schedule from July through December 2021. This was introduced at the last meeting, so the commissioners had an opportunity to take a look at it. Are there any questions or comments on the meeting schedule? Okay.
Madam Chair.
Yes.
Commissioner Jacob here. I don't want to hold this point up, but I haven't had a chance to look at this, and we'll communicate with council, and that I should be able to do that in a day or two. But and we'll get back to them if I do have any issues.
Okay, thank you very much. Does anybody else, did anyone else just in the interim have any comments or questions on the meeting schedule? Okay, great. If you do within the next couple of days, if you could just reach out to either General Counsel Stam or Deputy General Counsel Levine, that would be great. Is there any other new or other business?
Yes, Madam Chair.
Yes, Commissioner.
Can you hear me, Madam Chair?
We can. You're a little low for me, but we can hear you.
Is that better?
That is better. Thank you.
All right, thank you. I have several subjects I'd like to address today. The first is Executive Order 202.7.
Okay.
On September 22, 2020.
One minute.
The Albany Times.
Can you hear me?
Yes.
Okay, so I just want to make sure that I heard you. You said Executive Order, what was the number?
202.7.
Okay, and just to understand, is there going to be action requested on this?
Yes.
And what will the requested action be?
Requested action, I will move at the conclusion of my remarks that an informal subpoena be directed to the Governor's Council.
Okay, thank you.
Or an informational subpoena, better characterized.
Okay, thank you.
If I may continue, Madam Chair?
Absolutely.
Yes. On September 22nd, 2020, the Albany Times Union made a FOIL request to the executive chamber for records indicating the identities of those within the ambit of Executive Order 2.202.6, which was ultimately superseded by 202.7, and also asked if there were any gift exemptions or recusals. The response emanating from the Records Access Officer of the Executive Chamber was made dated March 5, 2021, and stated no records responsive to the request were found. In the most charitable characterization, this response from the Executive Chamber is disingenuous. In light of the Governor's Council's acknowledgement of the vaccination major domo status, the response can fairly be described as a sham. It also appears that some of the purported volunteers may not actually be volunteering, which is to say they're being paid. They're being paid by their employers, which invites many ethics questions, particularly if the employers have business before the state. Given our jurisdiction for Executive Law 94-9J, which states we shall advise and assist any state agency in establishing rules and regulations relating to possible conflicts between private interests and official duties, I move that an informational subpoena be directed to the Governor's Council for all pertinent information relating to Executive Orders 202.6 and 202.7, including a list of all individuals who have been or now are within the ambit of Executive Orders 202.7 or 202.6.
Okay, thank you. There's a motion on the floor. Do we have a second?
I saw Commissioner Weissman.
Yeah, I'll second it.
Okay, thank you, Commissioner Weissman. So we'll open it up for discussion. The first thing I just want to ask for clarification on, I think I understand that there was a vote related to this matter at the December meeting. I am not sure that vote fit. I'm not sure if it's exactly the same issue. General Counsel Stam, I don't know if you or actually Commissioner Levine, I don't know if you can shed any light on whether or not this is a different request.
Right.
Same
I
subject, different motion.
Yeah, I would agree with Commissioner Levine. There have been votes on whether to make a request for, there have been votes on whether to make a request for whether or not there's a process in place. There have been votes on whether or not to send a written letter to the Chamber making a written request. This is different in that it would be authorizing staff to issue a subpoena, which, if I understand, would be under its authority, the Commission's authority under 94-17.
Okay, thank you. Any questions or comments from any commissioner?
Madam Chair, George.
Oh. Yep, go ahead, Commissioner Weissman, and then Commissioner Fisher, I will call you next.
Okay, thank you very much. The reason I'm seconding this motion has to do with a recent article that appeared in the Washington Post relating to a particular person who apparently has worked for a company that has business interests down in the New York metropolitan area, sits on a board of an authority, and had the opportunity to use governmental resources not only for to do the volunteer work, but also in terms of lodging. So I'm just trying to, get to the bottom of where this really is in terms of where lines are being drawn in terms of volunteering and then other ethical obligations. So thank you.
Thank you, Commissioner Weissman. Commissioner Fisher?
Thank you, Chair. I wanted to ask about the practical impact of this. So if I'm understanding correctly, there are volunteers related to the COVID pandemic that we believe are not subject to our jurisdiction because they're exempted, but we want a list of who those people are, even though we don't have any jurisdiction over them. So I'm not sure what, if we had that list, we would do with it. And I believe, and there was a reporting on a different case where one of these volunteers had something referred to the public integrity unit, is that right, of the Attorney General's office. So if we don't have any jurisdiction, what would we do with this information if we had it? And I guess I'll leave it at that.
Commissioner
May I respond to Commissioner Fisher, Madam Chair?
Of course.
The provision of the executive law I cited says we shall advise agencies with respect to conflict of interest matters. We can hardly make an informed assessment and convey our assessment to the executive chamber if they are withholding the information with respect to the implementation of the executive order. I repeat for emphasis, given the fact that the governor's acting counsel has publicly acknowledged that the leader of the vaccination program is a supposed volunteer and has been vetted, it belies the assertion made by the Chamber's Records Access Officer that they don't have any information on this subject. Therefore, we ought to elicit it, make an assessment, and convey our conclusions, if any, to the executive chamber.
Thank you, Commissioner Levine. Do any other commissioners be heard on this one?
Madam Chair?
Yes.
Jim Gearing. Just adding to Commissioner Fisher's comments, I guess, and Commissioner Levine's concerns, I think with regard to a FOIL request, if a requester has a concern with regard to the response, the remedy would be an Article 78 proceeding. So I think the requester would have the ability to pursue that. In terms of advise and assist, I just personally don't see how issuing a subpoena falls within the category of advise and assist. So those are my comments.
Thank you, Commissioner Gearing. Commissioner Yates?
I wanted to take issue with an assertion that was made, and that is that we don't have jurisdiction. Without speaking to the propriety of a subpoena at this point in time, one thing that I've raised in 3 consecutive meetings here, and I don't want to ever put it aside, is the following. And that is that the executive law allows the governor to suspend temporarily laws that are necessary to be suspended to deal with a disaster or emergency. Fine. One of the Executive Order 202.6 and 7, which Commissioner Levine is referring to, says that anyone who is either volunteer or nominally paid is exempt from Public Officer Law 74. Public Officer Law 74 is the law that says that if you're acting as a public official with public authority, that you have to follow certain ethical rules. You can't contract to your family, to yourself. You can't award bids to yourself. You can't accept gifts. You can't accept bribes, et cetera, et cetera. So the question that arises is whether or not the governor has the authority to issue an order that says disregard all conflict laws and all conflicts concerns if a person's nominally paid you know, even if they're acting on behalf of the governor and they wield extraordinary power. I don't want to concede the point that was made earlier by another commissioner that somehow or other that's an authority that the governor has. I don't want to concede that the governor can wipe away all conflicts that may exist and say that it's being done because it's necessary to the dealing with the disaster or with COVID. So therefore, I think we have a legitimate concern about whether ethical laws are being violated. I don't have to remind you. I mean, if you all remember 2 years ago or 3 years ago when there was a disaster in Puerto Rico, and apparently we were told, according to newspaper stories, that a couple of people had no experience with electrical work at all, were given a $100 million or $200 million contract to do the work in Puerto Rico, and they were contributors, but they were not qualified. Now, you could call them volunteers if you want, but still, there was a lot of conflict that was done, and the electrical work in Puerto Rico was never done. We want to make sure that nothing like that ever happens in New York, and the only way to do that is that we keep vigilant in our responsibility to deal with ethical conflicts. I will not concede that a person who wields power on behalf of the governor or the state is free of examination by us if there's a conflict that becomes apparent.
Thank you, Commissioner. Commissioner Fisher?
It seems to me that the legislative branch of New York State government has a strong interest in these executive orders and recently has taken action and had discussion around whether they should be extended or modified. And it seems to me that that's the appropriate branch of government to contest the governor's assertion of what he's able to do under these executive orders. And I still don't see where we have any jurisdiction, but it seems like the state legislature has plenty. Likewise, if the state legislature wanted to change the statute that we operate under to give us jurisdiction over volunteers subject to this executive order, then they have every power to do that. And if they give that to us, I think we should take up that work. But I don't see why we should take up work that isn't ours to do. And therefore, I would be voting against this motion.
Thank you. Commissioner, I see your hand raised.
Adding to that, if I could, Madam Chair. Yeah, my recollection is that the statute also actually has provides the legislature the ability to overturn an executive order issued by the governor. So, to Commissioner Fisher's point. Thank you.
Well,
thank you. Yates, did you have a comment?
Yes, I'm not talking about changing the statute. I'm talking about following the statute. The statute says in particular that any suspension order shall provide for the minimum deviation from the requirements of the statute which is suspended consistent with the disaster action deemed necessary. In other words, all I'm saying is this: if the governor wants to issue an order that says, I don't care about ethical conflicts and Jacob can't look into them for a volunteer, then let's apply the statute. The statute says it's got to be the minimum deviation necessary to deal with the crisis. And that's all I'm saying is let's follow the law. I'm not asking for a change in the law.
Commissioner, I see your hand raised.
Yeah, I think my concern with that, and it relates to the concerns that Commissioner Fisher brought up, is that then what we would be doing, I believe, is challenging the governor's executive order based on our reading of the executive law. And I just don't think that's our place. I think that's the place of a court if there was a challenge, or I think within the executive law, the legislature has the ability to overturn an executive order. So I just don't, from a jurisdictional standpoint, I just don't see our place with it.
If I may again, just to respond,
Yes.
That's actually where I maybe vary from Commissioner Levine's motion. His proposed remedy is to find out, first of all, who is exempted. I had previously made a motion, or at least raised the issue. I forget. I don't think it was a formal motion, on 2 or 3 occasions, and that is that we ought to get clarification as to whether or not we have jurisdiction when we become aware of a conflict. If someone submits a sworn affidavit to us telling us that a volunteer has self-dealt or taken a gift or honoraria or some kind of self-reward to himself or her family or his family, then the question is, do we have the authority to go forward or not? I asked counsel last 2 times to write to the governor's council to find out whether or not the intent of the governor was to exclude us or preclude us from being able to act on a complaint when there's a clear conflict. That hasn't happened. So we could do an informational subpoena the way Commissioner Levine has offered, or on the other hand, maybe it's appropriate for us to go ahead and ask for a formal opinion from the Attorney General. We could ask Attorney General Letitia James, does she think that total preclusion of any examination of conflict by this commission is lawfully covered by that executive order? And I'd actually welcome, if I can't get it from Governor's Council, then I'd like to get it from Attorney General James.
Okay, so before we move on, does anyone have any additional comments? Okay. Commissioner Yates, are you seeking to amend Commissioner Levine's motion at this time?
No, I'd rather continue this discussion among the commissioners.
Okay. So seeing no other hands, Deputy General Counsel Levine, can you please repeat the motion that's on the floor?
Yes, ma'am. And I would actually ask that Commissioner Levine clarify, because I was trying to keep up on notes, but the motion was to issue an informational subpoena to the Governor's Council for all individuals covered by Executive Order 202.6 and 7. Was there additional material that you were seeking, Commissioner Levine?
Any other information related to recusals by volunteers?
And any other information related to recusals by volunteers?
Okay.
Yes.
Madam Chairman, this is
Yes,
Dan Horowitz.
Commissioner Levine.
A question, really, I guess, for the General Counsel. First of all, what authority, what section of Section 94 would this subpoena be issued pursuant to?
I believe it would be under 9417, which gives the commission the ability to, 17C, which gives the commission the ability to issue subpoenas.
Now, has the commission ever voted to issue a subpoena under 17C in the public session?
No, not that I would recall.
And is the reason that the commission has issued those subpoenas historically, is that correct?
Yes, the commission, any subpoena the commission issues is pursuant to 17C.
And historically, those 17 subpoenas have been issued confidentially because they were pursuant to the confidentiality requirements under the Public Officers Law, right?
The majority of subpoenas that have been issued under 17C have been done in connection with investigative matters, and so they have been covered by the confidentiality that applies to investigative matters. I think generally speaking, if we're dealing with a matter relating to an individual, whether it's subject of an investigation, a corporate entity, a lobbyist, or a client, in any context. If it relates to an individual, we've done it in executive session.
So I'm curious then, if the commission was to vote to issue the subpoena that is the subject of the motion, would the return of the subpoena, the information provided in response to the subpoena, be covered under the confidentiality rules of the public officers law?
Of the executive law.
That's an important question, given historically the use of these subpoenas for investigative matters. And this certainly sounds like it's more of an investigative question than anything else. So I'm curious about whether, notwithstanding the fact that this motion is made in the public session, whether the return would be confidential. And if the answer is unclear, I think that's also important for the commission to understand.
So I think it is unclear. I don't know that, again, this is not a situation we've ever contemplated before, but I certainly would recommend that if the return included individual guidance that was given to any volunteers or anyone else who's covered by 202 or 202.6 or 7 of the executive order, that is not the kind of information that we would normally make publicly available. And so that has to be given some thought. And I don't have an answer prepared. Right.
Yeah, thank you. Thank you, Madam Chair.
No problem at all. Are there any other questions or comments with respect to the motion on the floor? Okay. So why don't we move ahead to the vote on the motion, unless General Counsel Stam, considering the last question, you think your recommendation would be that we need to hold until we have an answer?
I think the commission could consider, it's really for the commission to decide. It's an open issue, and if that's the reason why commissioners don't want to do this, approve a subpoena in the public session, that's certainly a legitimate concern for commissioners to have in voting on this motion. And other commissioners may not share that concern. So I think it could go forward.
Madam Chair, I do think that I would like to have a more cogent analysis from the staff about the implications of the subpoena. First, since this is the first time we've done this, and the fact that these kinds of subpoenas have historically been used, sounds like almost exclusively for the conduct of investigations. And while I think the public policy questions that commissioners have raised today about adherence to the conflict of interest rules is of course critical, and of course something that generally is within our purpose. I do think that a more cogent analysis of the answer to this question is important for commissioners to understand before we're asked to vote on something like this, particularly because notwithstanding the fact that some commissioners who, without naming these people who are the subject of newspaper articles, there may be others who are not as high profile as these people and whose rights may be implicated. And I think we need to be sensitive to that as well, notwithstanding the important public policy concerns that commissioners have raised about this issue.
Thank you, Commissioner Horowitz. Commissioner Levine, with the point that has been raised, are you amenable to tabling your motion until the next meeting so that commissioners can receive additional guidance on the matter raised by Commissioner Horowitz, or would you like to proceed with a vote?
I am not amenable.
Thank you.
I agree with the proposition that whatever information that we receive should be reviewed by the commission with respect to whether it should be divulged to the public or not. That's our prerogative as a commission. I will not withdraw the motion today.
Okay, thank you.
Madam Chairman, I do have a point of order then. Since the author of the amendment has conceded that the subject matter of the subpoena is subject to the executive law confidentiality rules that we abide by, then I would submit that the issuance of the subpoena itself is not appropriately discussed in the public session. I think the motion is out of order.
I do not agree with learned counsel, Madam Chair. I am simply accommodating a concern. In the normal course, we would, as a commission, review the material. If it appears that there is some legal imperative to hold it in camera, then of course we should do that. But it should not impede the vote on the resolution today, nor is there any legal requirement whatsoever that the motion be confined to the executive session.
Thank you, Commissioner Levine.
Madam Chair, Commissioner Jacob here.
Hi, Commissioner Jacob.
I cannot agree with the reading of Section 17C that Commissioner Horowitz is putting to it. Section 17 begins by saying, in addition to any other powers and duties specified by law, the Commission shall have the power and duty to. It begins with promulgating rules. If in connection, for example, with promulgation of a rule, this Commission needed information and had to issue an informational subpoena, I would not read 17C to mean that that could not be done. We need the ability as a commission, since we regulate and we also enforce. The notion of reading Section 17 as being exclusively an enforcement provision is belied by the introductory language, in addition to any other, and promulgation of rules follows immediately. So we should, and we do, have the power to issue informational subpoenas in order to conduct the business of the Commission. And to read 17C as meaning only enforcement subpoenas, because our recollection is that we have not issued any in connection with our regulatory or other duties, is, in my view, an incorrect reading of Section 17. And I would urge that we do vote on this today. And would agree with Commissioner Levine in that regard. Thank you.
Thank you. Commissioner Deering?
Just looking at 17C, it says, conduct any investigation necessary to carry out the provisions of this section. Pursuant to this power and duty, the Commission may issue subpoena. So, number one, with regard to that, I don't see, the motion, as I understand it, is to issue an informational subpoena under the authorities to advise and assist. I don't see that. And then for 17C, the way I read it is that clearly relates to conduct an investigation. So in looking at this, I question whether we even have the ability to issue the informational subpoena as proposed. And if somehow we had that authority under 17C, which I'm not seeing it, I don't see how we have this vote in public, because I think it would be subject to the confidentiality provision. Thank you.
Thank you, Commissioner Deering. Okay. At this point, I think I'm going to call for a vote on the motion on the floor. All in favor?
Please raise your hand until I call your name on the motion. Let's see, McNamara in favor, Weissman, Ron. I haven't missed anyone. Okay, let me record that. And I'll call the remaining roll. Commissioner Cohen.
Wait, Commissioner Yates had his hand up, but I'm not sure. He's voting, Commissioner Yates, you voting in favor? You're muted.
Sorry, I stepped away for a second and I'm back. That's all I was saying.
Okay, would you like to vote in favor?
We can't hear you.
Okay, I think, Martin, you can keep going.
You're muted, Commissioner Yates.
Okay. All right, I'll come back at the end. Commissioner Cohen on the motion.
No.
Commissioner Deering.
No.
Commissioner DePiero.
No.
Commissioner Fisher.
No.
Commissioner Horowitz.
No.
Commissioner Jacob.
Yes.
Commissioner Levine.
Yes.
Judge McCarthy.
Yes.
Commissioner McNamara, I recorded. Judge Yates.
Yes.
Thank you. And Chair Varlock.
No.
That's 1, 2, 3, 4, 5, 6, 7 in favor. Motion fails.
Thank you. Commissioner Levine, your next item?
Yes, Madam Chair, if I may ask staff, what is the status of the records access policy proposal that was before us several meetings ago?
It's just pending. We've obviously other issues became more pressing and needed to be addressed by the Confidentiality and Records Access Committee. So we can bring it back to the commission at a future meeting. It's just there's a lot on the agendas.
Yes. Has it been established to your satisfaction, Madam General Counsel, that the prior discussion has it that disclosure would be made of an inquiry with respect to an FDS to the filer if the commission were subject to FOIL? And that the practice mandated by the New York City Charter and the New York City Conflicts of Interest Board is to divulge to the filer if an inquiry has been made.
Commissioner Levine, is this an informational point or will you have a related motion?
Well, I may have a motion depending on what responses I get, Madam Chair, from staff.
Okay, thank you.
So, I think as a matter of law, the Conflicts of Interest Board, it's in the city charter, I believe, and if anyone, Martin or someone else can correct me if I'm wrong, I think as a matter of the city charter, the Conflict of Interest Board is required to disclose to filers if their FDS is requested. We've researched the question of whether FOIL requests are publicly available under FOIL, and they are, but obviously FOIL exceptions would apply if those requests are made. So as you mentioned, we are not subject to FOIL, but if you're making the analogy, then if we were subject to FOIL, I think that requests for public records would be publicly available, but again, subject to the exceptions under the FOIL law.
Thank you. I now have a question on follow-up to the staff. During the past 3 years, has any request been made by the executive chamber, someone reasonably supposed to be affiliated with the executive chamber, or the Office of Inspector General for the FDS of any member of the commission?
So I don't have that information, but this is an open question pending before the commission whether this information is going to be made publicly available. And so staff cannot answer that question absent a vote of the commission to disclose such information. So the current state of the records access regulations is that that information is not information staff makes available. the proposal in the records access, the amended records access regulation was to allow filers to find out if their FDS has been requested, but not who made the request. And so your question goes to the heart of the issue, which is pending before the commission and has not yet been decided. So staff can't answer it in this setting.
I'm not sure I
ruling from the
follow.
commission.
I'm not sure I fully apprehend your answer, Madam General Counsel. I'm asking a question. Has the Executive Chamber, someone affiliated with the Executive Chamber, or the Inspector General made a request within the last 3 years for the FGS of any commissioner? I'm not asking you to identify a specific commissioner. I'm simply asking, has such a request been made? Surely you must know the answer.
I understand your question, and I'm saying that until the commission rules on this issue, I can't answer the question. And I would direct staff on the legal basis they should not answer the question until the commission rules on this issue. But I would also ask, if this goes to your personal request as to whether or not your FDS has been requested by the chamber or the Inspector General's office, then I would question whether you should be raising this in this context.
Well, I believe under the conflict of interest policy of the commission, the ultimate determination of whether there's a conflict of interest on the part of a commissioner participating is the prerogative of the commissioner. And I believe that the question that I have just put to you does not constitute a conflict of interest on my part. Now, on the follow-on, are you asserting now that the commission institutionally is not entitled to an answer to this question?
No, I'm saying the commission votes on the issue of whether staff can disclose who has made requests, then staff will follow that directive. But this is, as it stands, the commission hasn't ruled on this issue. So until the commission can address this right now, if you want to make a motion, the commission can vote on that motion, and then staff will do what the commission directs it to do. But as it stands right now, this is not information that the staff makes publicly available. And so until the commission rules on that issue, whether it's by motion or by changing the regulations, staff can't answer the question in a public session.
But this term publicly available includes within its ambit communication only with the commissioners?
My understanding
Is it your position that staff is not authorized to answer the question that I have just put to you?
So
in the public
without
session,
identifying any specific
one moment.
inquiry.
I'm sorry. Go ahead, Commissioner Levine.
Is it the position of staff that the generic question, has any inquiry been made by the Executive Chamber of the Inspector General's office for any commissioners without identifying the specific commissioner, that the staff will withhold that information from the commission?
So,
not withholding the information from the commission. The commission hasn't addressed this issue. Once the commission decides the question, then staff will share the information, but I can't share it, and I would caution any staff to share the information in the public session absent a decision by the commission.
Well, on the follow-on, Madam General Counsel, suppose the same question were put to you in the executive session. Would you answer the question in the executive session?
So
if we were asked the question, go ahead. Sorry, Chair.
Sorry, that's okay. I just want to make sure that I understand, General Counsel Stan, what you're saying. What I understand is the general policy of the staff at this time is not to reveal who has requested a copy of the FDS, whether it's the executive chamber or any other individual, and that absent a vote of the commission to change that policy, that is the way the staff would proceed. Is that correct?
It's not that it's a policy. The commission has approved records access regulations that dictate what information staff makes publicly available, and staff follows those rules. And those rules currently do not cover the information that Commissioner Levine is requesting. And because this is a matter that is of debate among the commissioners right now, whether this information should be publicly available, I'm uncomfortable answering the question in a public session until the commission has ruled on the question. So if it's not a matter of policy for staff right now, it is a matter of policy for the commission, and the commission can change its position by a motion, or it could change the regs, and then staff will have direction. But this information falls into the category of information that is currently not publicly available, and it's completely in the commission's discretion whether it should be or shouldn't be, but it's not in staff's discretion.
Well, that response, Madam Chair, prompts me to renew the question. Would you answer the question that I have put to you in the executive session?
So Commissioner Levine, based on what General Counsel Stam just indicated, I don't know that, and of course she can answer, but it doesn't seem to me that it would matter. It seems as though the current rules don't allow for the sort of the provision of that information. But General Counsel Stam, correct me if I'm incorrect, if I'm wrong.
That's where I am right now. I'm happy to discuss it further in executive session.
Yes. Well, thank you very much, Madam General Counsel and Madam Chair. I move, Madam Chair, that the staff be directed to answer the question. Within the last 3 years, has any request been made by the executive chamber, an individual who reasonably could be construed as being affiliated with the executive chamber or the Office of Inspector General, asked to review the financial disclosure statement of any member of the commission, past or present?
Thank you. So there's a motion on the floor. Is there a second?
Second, Commissioner Weissman.
Thank you, Commissioner Weissman. The floor is open for any questions, comments, or debate on the motion. Commissioner Deering?
This is a question for Commissioner Levine regarding his motion. Is that to disclose publicly or in executive session?
Publicly.
It is just one comment on the discussion that happened before. If it's not able to be released publicly pursuant to the regulations, I don't even think that JCO commissioners could waive their regulations. I think we'd have to amend the regulations. That's my only comment.
Thank you, Commissioner Deering. Commissioner Fisher?
I'm planning to vote against this motion. I don't believe it's right for us to give ourselves some sort of special access to information. If this applies only to requests about commissioners and not to other people that file disclosures, we're not setting any rules about somebody else that makes a request about whether someone from the executive chamber or elsewhere has asked for financial disclosure statement about them. So I don't think it's right to give ourselves access to information until we've settled the larger question of, are financial disclosures filed by anyone subject to disclosure when someone else asks for that record? So I think we should consider this in a much broader way, and we'll vote against this.
Well, may I ask, Madam Chair, Commissioner Fisher, a question?
Of course, Commissioner Levine.
Yes, Commissioner Fisher, if the motion were to amend the records access policy to provide that our policy be consistent with the protocol of FOIL or the New York City Conflict of Interest Board, would you vote in favor of that motion?
Not at this time. My concern would be whistleblowers. I would want to make sure that there were protection if someone in a whistleblower scenario was obtaining this information from us. they would want to know, I think, that we weren't simply going to turn their name over to their boss or someone else that they might be, I guess, about to or preparing information regarding to a whistleblower scenario. So I think there's a lot of work that needs to be done about the different scenarios in which someone would ask to find out whether someone had requested information about their financial disclosure and whether it was retaliatory in nature, as it might be in the case of a whistleblower. So no, as it currently stands, I would continue to be opposed.
On the follow-on, Madam Chair, Commissioner Fisher, surely you're not positing that there's any issue with regard to retaliation regarding the executive chamber. So suppose the motion were made that any filer could ask to have divulged to that filer whether the executive chamber that asked for the FDS. Would you vote for that motion?
I believe we should adopt the policy after considering the various ramifications and apply it not just to the executive chamber or this entity or that entity, and not just commissioners or commissioners plus some other. I think there should be a general rule applied to who can request information about who has requested an FDS that they filed. And until we've gone through that with care, I'm not willing to vote for any new policy along the lines you're suggesting.
Thank you, Commissioner Fisher, and thank you, Madam Chair.
No problem, Commissioner Levine. Are there any other questions or comments or debate on the motion that is on the floor? Okay.
Madam Chair, Commissioner Weissman, this is to General Counsel Stam. The question raised or the issue raised by Commissioner Fisher regarding whistleblowers, would that fall within the exceptions in 87.2 of the Public Officers Law, Article 6?
I would have to look at the exceptions. As you know, we're not subject to FOIL, so I don't regularly apply them or interpret them. So I don't know the answer. I don't know that we would always know if somebody's a whistleblower, because we wouldn't necessarily be aware of why they're asking for the FDS. They don't have to state a reason. So, you know, we wouldn't necessarily have that information unless they filed a complaint with us.
But that same logic holds true whether Chair Varlak or I work for the Department of Transportation and somebody asked for our personnel file and they got it, and then, you know, we could go ask for it. We could file our own FOIL request to figure out who FOILed for our personnel record, correct? This is the
Correct,
thing of the absurd we're talking about.
It was exempted from FOIL, so there was a decision when the law was passed not to have this type of information necessarily publicly available, and it was left to the Commission's discretion. We're specifically exempted from FOIL. The statute specifies what records are publicly available. These are not included. So there are different reasons for why that might be. I can't begin to put my head in the mind of why that was done, but we are different. And for that reason alone, the law makes us different.
Well, Monica, at the end of the day, I think Commissioner Levine's motion is more or less just about getting us to the place in this particular instance where every other state agency is. Okay, and that's all.
Currently, his motion is just about commissioners getting information about their filing. So I understand if there's going to be a broader policy change recommended, whether it's going to be by motion or as part of the records access regulations, but the current motion is about commissioners getting information about their filing.
Well, then I'm going to ask Commissioner Levine to expand his motion so this commission ends up being treated as all other state agencies are.
Well, if I may, Madam Chair, first of all, I want to clarify the characterization made of the pending motion by our general counsel. The pending motion does not require staff to divulge the names of the commissioners whose filing has been requested, if at all. It certainly does not require divulging to the particular filing commissioner. It simply directs the staff to answer a very narrow question. As the Executive Chamber or the Office of Inspector General within the last 3 years asked to see, review an FDS of any commissioner presently serving or was served during the period. Doesn't ask for anything else to be divulged. Just the answer to that question. Has any inquiry been made? That's the motion.
Okay. So Commissioner Levine, did you have, I see you, Commissioner Yates. I just want to ask Commissioner Levine, do you have a response to Commissioner Weissman's question to you?
Yes. When the gubernatorial cohort blocks this motion, then I'll make that motion.
Commissioner Yates?
I want to follow up on something that Monica Stam and Commissioner Levine were just talking about, and that is narrow in on exactly what information is going to be available and to whom, because it's important to me. I read Section 19A of the executive law to say that notwithstanding FOIL, the only records of the commission which shall be available for public inspection and copying are, and then it itemizes some. So if this motion in any way would lead to public inspection or copying of a record that's not listed there, then I would vote against it because I think it violates the executive officer's law, or the executive law rather. On the other hand, if what Commissioner Levine's motion is merely that a person whose records are being sought can be notified that his or her records are being sought, and it's not available for public inspection or copying, and it will be information that's solely available to the subject of the inspection, then I could support the motion. So I really need clarification on that because I don't want us violating the executive law.
Madam Chair, in response to Judge Yates, you have articulated better than I would have the second omnibus motion that I'll make once this motion is defeated. That's pending.
Okay. So let's move to vote on the motion that is currently on the floor. Deputy General Counsel Levine, can you repeat the motion, please?
Yes, ma'am. To direct staff to disclose whether any requests for a commissioner's financial disclosure statement have been made in the last 3 years by the executive chamber, someone reasonably affiliated with the executive chamber, or the Office of Inspector General.
All in favor?
Please hold your hand up until I call your name. I see Commissioner Weissman and McNamara. I'm going to record that. I'll call the remaining roll. Commissioner Braun. I didn't hear you, but I'll come back to you. Commissioner Cohen.
No.
No.
Thank you, Judge. I heard you now. Commissioner Deering.
No.
Commissioner DePiero.
I would like to abstain. I've heard two different legal positions on this, and with the lack of background, I would like more information from staff. I just don't think it's appropriate for me to vote with two distinct determinations from a legal standpoint.
Thank you. Commissioner Fisher.
No.
Commissioner Horowitz.
No.
Commissioner Jacob,
Yes.
Commissioner Levine,
Yes.
Judge McCarthy,
Yes.
Judge Yates,
No.
Chair Varlak.
No.
1, 2, 3, 4, 5 in favor, 1 abstention. Motion fails.
Thank you.
And at this juncture, Madam Chair, if you'll indulge me, I now make the motion as expressed, outlined by Judge Yates.
Yes, please proceed, Commissioner Levine. Are you making the new motion?
I'm making that motion, yes.
Okay, so Commissioner Yates, could you repeat the motion just so that we're clear on what the current motion is?
Somehow this has become my motion. I will articulate Commissioner Levine's motion. Commissioner
Why
Levine.
don't you move it and I'll, Your Honor, why don't you move it and I'll second you, all right?
I would move that any commissioner can request from staff and be advised if a request to inspect their FDS was made by anybody in the executive chamber or connected with the executive chamber in the last 3 years.
Okay,
second the motion, Madam Chair.
Thank you.
Commissioner Yates, maybe I missed something. Isn't that the same as Commissioner Levine's?
No, the only difference is this would not be publicly available or disclosed publicly in any way. It's merely advice between staff and that commissioner and the requesting commissioner.
Okay, so the motion has been made, properly seconded. Is there any discussion? Commissioner Deering?
Just echoing some comments that Commissioner Fisher made before. I think that Jacob commissioners should be treated the same as the public. Thank you.
Thank you, Commissioner Deering. Any other comments before we move to a vote on the second motion? Okay. I will add that I too believe that we should have a comprehensive approach to these matters and there not be carve-outs for commissioners.
I'd like to table my motion in that case. I agree with you. It should go to the confidentiality committee.
Thank you, Commissioner Yates. So at this point, we will move on. Are there any other, yes, Commissioner Yates?
I have a new motion, if you don't mind. And I'll try and keep this brief. The Attorney General is authorized to issue opinions and advice to commissions and commissioners. They do so regularly. You can look up the opinions. You see their advice all the time. I would ask that on behalf of the commission, that we write a letter within the week to Attorney General Letitia James and ask an opinion as to whether or not, if we receive a complaint of a violation of Public Officers Law 74 that is sworn incredible, if we have the authority to investigate it, notwithstanding Executive Order 202.6 and 202.7.
Okay. Is there a second?
Second.
Thank you. Opening the floor for comments and discussion. Okay. Seeing no hands, we can move to a vote. All in favor?
Please raise your hand. I see Commissioner Yates, Commissioner McNamara, Commissioner Weissman, and Judge Braun. Yates, Weissman, McNamara, and Braun. I'll call the remaining roll. Commissioner Cohen,
No.
Commissioner Deering,
No.
Commissioner DePiero,
No.
Commissioner Fisher,
No.
Commissioner Horwitz,
No.
Commissioner Jacob,
Yes.
Commissioner Levine,
Yes.
Judge McCarthy,
Yes.
Chair Varlak.
No.
1, 2, 3, 4, 5, 6, 7 in favor. Motion fails.
Is there anything else under new and other business?
This is the last thing I'll raise.
May I just ask? I didn't hear the last statement of Council Martin. Did that motion pass or fail?
The motion failed. 7 in favor.
Thank you, Martin.
Commissioner Yates?
I'll be brief. This is maybe the 6th time in a row that I've raised this, but the fact that the Senate Democratic leadership refuses or fails or omits to follow the law, which requires appointment of a filling of a vacancy within 30 days on this commission, means that we've gone without a representative by the Senate Democrats for almost 2 years. I just want to remind people that by not following that law and appointing someone within 30 days, effectively the Senate Democrats are voting no on any investigation. So if someone comes forward with a sexual harassment complaint or with any other complaint that they may be reading about in the papers that's of interest to anybody about conflicts of interest or malfeasance, whenever we take a vote on that, there's an absolute no vote by the Senate Democratic representative, because that's what a vacancy is a no vote.
Is there any other new and other business? Okay. At this time, can I please have a motion to move into executive session?
If I may, Madam Chair, I have some questions for staff. With respect, and I want to emphasize at the outset of this discussion, I'm not addressing any particular opinion that they have previously rendered, but I want to understand in generic terms the application of opinions of the predecessor commission. Commissions, plural. Commission on Public Integrity and the Ethics Commission preceding the Commission on Public Integrity.
So very quickly,
So when the staff, I'm sorry, Madam Chair.
I'm sorry, I didn't mean to interrupt you. I wanted to ask, is there going to be a related motion to these questions?
No.
Okay. I'm sorry, please proceed.
Thank you. The predecessor commissions, at least the predecessor commission, the Commission on Ethics, has rendered opinions on various subjects. Those are taken as precedent by staff when rendering opinions. Do I understand that's the protocol?
I think that question would be for.
I'm sorry, Commissioner Levine, I'm sorry, I didn't understand the question.
Well, maybe the question, maybe that's because I didn't put the question artfully. Opinions that are rendered by our predecessors, though the statute says that they obtain unless we overrule those opinions, correct?
Correct.
Without getting into the arrangement for the governor's book, it has been the case in the past that state employees have requested opinions from our predecessors on the subject of publishing books, pamphlets, manuals, and the like. Is that not the case?
Yes, that's the case.
Right. When there have been various opinions on the subject of publishing rendered by the predecessor Ethics Commission in 95 and 98 and 89. If there is a perceived conflict with respect to those opinions juxtaposed with each other, would that, under the current policy, then be deferred to the commission to decide what the precedent is, or does the staff make its own determination?
I'm not sure what you mean by a perceived conflict. If there isn't precedent that is in effect and on point, then it raises a novel question, we would take it to the commission. So either one. If it's raising a novel question, but I'm not sure what you mean if there's a perceived conflict.
Well, let me take it out of the realm of the ethereal. 9525 of the State Ethics Commission, opinion 95-25, held that if a public officer were publishing on a matter that the public officer was involved with, which was within the ambit of their current duties and responsibilities, the royalties could not be gleaned from the publication. There was further opinions, 9815 and 9816, which could be construed to reach different conclusions from 9525. So my question is, when staff has to address that kind of a juxtaposition, would it normally be deferred to the commission, or would the staff resolve the differences?
So, my understanding, but Michael Sand is the Deputy Director of Ethics Guidance, is on the call, and he can confirm this and might be better positioned to answer questions about the specifics of the advisory opinions. But my understanding is it's not a juxtaposition, but the 9815 clarifies the rule, the precedent, and then it very clearly says to the extent that the prior decision is inconsistent, it's overruled. But that's what I think. But again, Mike Sand could jump in here. So I don't know that it's a juxtaposition or a conflict.
So
it's more recent precedent that deals with the question and comes to a different conclusion. I think it overturns the precedent with respect to one point. But Michael, you might be muted. Hold on, I'm sorry, I'm looking at the advisory opinion right now.
Monica, can you hear me?
Now we can, yeah. I'm just trying to find the language. I thought that there was language in the more recent advisory opinion and recent thing, 98, which is very clear about its effect.
Monica?
Yeah.
This is George. Let me read you the language that modified 9525. The prohibition arises only when the job relatedness of a published work is used to demonstrate that it is part of an employee's job duties. That's the only thing left of 9525.
Right. So I'm not, again, I don't think there's a juxtaposition or a conflict. I think that 9815 addressed this question more recently and resolved it. But I thought there was more explicit language. I just don't know. Michael, do you know?
Monica, can you hear me?
Yeah.
Yes, that language is in the opinion, and I'm looking for it now. I have the opinion printed out.
Okay. So Commissioner Levine, I know you had some questions for staff, and I don't know if there is a motion related to it, but I will note that we do have quite a bit of business to continue on. Do you have any other questions related to this?
Madam Chair?
Yes, Commissioner Weisman.
There's a short paragraph in 9816 that maybe Michael Sand can read which clears up the language from 9815. But it's short and it won't take more than a minute.
Wait, Madam Chair, this is Rob Cohen. Can I just be heard for a brief moment? I'm scratching my head, kind of wondering what we're doing here. We're reading opinions, and people are making interpretations seemingly on, well, not staff, but they're making their own interpretations. Some of them would seem to be on the fly. I just don't understand what benefit anyone is deriving from this here. And if the discussion does merit if this topic does merit further discussion, and this is precisely the type of issue that should be raised beforehand, circulated beforehand. People can muse over it, cogitate over it, and then have an informed discussion. But right now, there's vast moments of silence where people are reading opinions and excerpts thereof, and it just seems a complete and utter waste of time. That's my 2 cents.
Thank you, Commissioner Cohen. So Commissioner Levine, I know I asked you this at the beginning of this particular point. Do you intend to make a motion at this time? If not, my inclination would be, it seems as though there is something here that you want to discuss. The opinions that are being cited, while I think General Counsel Stam is looking for some, I think Michael is as well. Certainly the rest of the commissioners, I certainly don't have these opinions, and I would like to keep moving with the meeting because again, we have a lot of business to discuss. So my question would be, is there a motion that you intend to make? I'm not sure if we lost him.
Thank you very much, Madam Chair. I certainly want to accommodate you if I can. I will exit this subject today with the nub of my inquiry. It appears to me, can you hear me, Madam Chair?
Yes, we can hear you.
Yes, it appears to me that there is a lack of clarity in how several of these opinions should be read together and what conclusions should be drawn. Now, what I want to know is, given the fact that 9815 changed the 95 opinion, and then 9816 changed 9815, I would like to hear from staff how they reconcile the differing opinions and whether it's their prerogative to do that or the commission.
Okay.
And I will certainly be happy to hear it at the next meeting.
Thank you very much, Commissioner Levine. I appreciate it. At this time, can I please have a motion to move into executive session pursuant to Executive Law 9419B?
I'll move Deering.
Thank you, Commissioner Deering. Can I have a second?
Okay.
I'll second Fisher.
Thank you.
Chris, I'm going to go move the car. Yeah, I'm going to go move it, Dexter.
Well,
okay. Chris, I'm going.
Walt, Are we in
Well,
executive session?
can you mute Commissioner Cohen for a moment?
We didn't take a vote. Hold on, let me mute him. I'm sorry.
Oh, I'm sorry.
Yes, go ahead. I did mute Commissioner Cohen at the moment.
Thank you. All in favor of moving to executive session? Aye.
Thank you. I see Commissioner Yates, Fisher, Deering, McNamara, Weissman, Braun, and the chair. Commissioner Cohen, I know, is indisposed. I'll come back to him. Commissioner DePiero.
Yes.
Commissioner Fisher voted. Commissioner Horowitz.
Yes.
Commissioner Jacob.
Yes.
Commissioner Levine.
Yes.
Judge McCarthy.
Yes.
Yates, and I'll come back. Commissioner Cohen, are you there? No. Okay. 12 in favor.
Rob, wait, Commissioner Cohen's muted. Well, you have to take him off mute.
I'm trying to. It's not letting me unmute him. It sends a request to tell him to unmute. So it's not.
Okay.
He has to unmute himself.
I don't think he would object if we went forward, but if he does, we can revisit the motion after the public session.
It carries, so.
12 in favor. We're out.
All right. Stand by, please.
Thank you.
Madam Chair, we're back in public session.
Thank you very much. General Counsel Stan, can you please report on our executive session?
Sure. The commission discussed personnel matters, approved 2 settlement agreements, commenced 1 substantial basis investigation, and authorized steps in several investigative matters, closed 1 matter, and discussed several other investigative matters.
Thank you. Is there any other business before the commission? Okay, seeing no hands, hearing nothing. Please note the next commission meeting is scheduled for April 27th. May I have a motion to adjourn the meeting?
So moved, Deering.
Second, DePiero.
Thank you. You have the motion and the second, Deputy General Counsel Levine?
Yes,
Great.
yes, Chair.
Thank you. All in favor?
Deering, Fisher, McNamara, Braun, Weissman, Cohen.
Yes.
DePiero.
Yes.
Yes.
Jacob.
Yes.
Levine.
Yes.
McCarthy.
Yes.
Motion carries.
Thank you. Have a good day.